All right, we are now belatedly on YouTube also. So Ms. Wood is now being broadcast globally. That screen there. All right, Ms. Rivers, you ready? So we are dealing with positions 1 and 2 on our calendar, both involving Mr. Jordan. There's a 15 SC 149970 and a 16 SC 145475. And it's my understanding, Ms. Wood, that you and Mr. Jordan have agreed to a negotiated disposition with Ms. Charles on behalf of the state.
Yes, Judge.
Okay, Ms. Charles, it sounds like certain things are being reduced. So if you'd start with that, but let me tell Mr. Jordan how this is going to work. In a moment, Ms. Charles is going to put you under oath. Once you're under oath, you'll need to answer all of her questions truthfully and completely. If you've got any questions of your own, please let Ms. Wood or me know, because I need to be comfortable that you understood what we're working through. And I don't think there are going to be any surprises or anything real complicated, but sometimes it's hard to hear or it's just not going the way you thought it was. And I'm relying on you to say, stop, I got a question. Will you do that?
Yes, sir.
Okay, Ms. Charles?
Mr. Honor, on your, as you have stated, some of the charges are being reduced. The first case, 15 SC 139970, counts 2 and 3 are being no cost. Count 1 is being reduced to simple assault, family violence, OCG 86520, misdemeanor. And count 4 is the same.
Got it. And then in the 16 SC case, everything as is?
They are, count 1 is being reduced to terrorist offense misdemeanor and 161137 D1. And counts 2 is
161137 D Delta 1. Okay, thank you.
Mr. Jordan, please raise your right hand. Do you swear or affirm that any statement or testimony you shall give in front of the court will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name.
Gregory Jerome Jordan II.
Are you at this time taking any more than medicine, drugs, or alcohol?
No, ma'am.
How old are you?
29.
How far do you go to school?
You can put your hand down now.
Oh, I'm sorry.
That's okay.
8th grade.
Is English your native dominant language?
Ma'am.
Is English your native dominant?
Yes, ma'am.
Do you understand the point provided to assist you? Did you understand what I've explained?
Yes, ma'am.
And do you understand that you're being charged with the following offenses? Under 16 SC 1 45475, you're being charged with the first count, terrorist threats misdemeanor. Second count, simple battery, family violence.
Yes, ma'am.
Under indictment 15 SC 19970, you're being charged with one count, simple assault, family violence. The second count for cruelty to children in the third degree.
Yes, ma'am.
And do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, refuse to enter any plea to law, the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the waiver of rights form of your attorney?
Yes. Yes, ma'am.
And is that your signature on that form?
Yes, ma'am.
And at this time, the state moves to tender the waiver of rights form to you.
Okay. Where is it? It's with you? No, that's fine. And Ms. Wood, you signed it as well?
Yes, Judge. Let me just double check. Yes, I did, Judge.
Great. Thank you, Ms. Charles. I'll take that. Appreciate it.
And Mr. Jordan, have you had enough time to speak with your lawyer about all of the charges and the indictments, accusations against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Would you like more time to discuss the case with the lawyer? Mr. Jordan?
No, ma'am.
Are you satisfied with the lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment accusation for the purposes of this plea?
So waived.
Do you waive any and all defects in the indictment for the purposes of this plea?
So waived.
Your Honor, the state is unaware of any outstanding warrants relating to these charges. Mr. Jordan, do you remember being arrested on these charges?
Yes. Yes, ma'am.
Answer. Yes.
Yes, ma'am.
As your attorney advised you, the minimum maximum sentences each charge that should be guilty to carry.
Yes, ma'am.
Indictment 16 SC 145475. Count 1, terroristic threats, misdemeanor, up to 12 months.
Yes, ma'am.
Count 2, civil battery, family violence, misdemeanor, up to 12 months.
Yes, ma'am.
In indictment 15 SC 139970. Count 1, civil assault, family violence, misdemeanor, up to 12 months.
Yes, ma'am.
Count 4, cruelty to children of third degree misdemeanor, up to 12 months.
Yes, ma'am.
Do you understand that today you are entering into a negotiated plea of guilty?
Yes, ma'am.
Which means the state will recommend the following sentence. Your Honor, under indictment 16 SC 15475, the state recommends on count 1, 12 months probated, on counts 2, 12 months probated. On the 15 SC.
Before you go to the 15 SC, are those running consecutively or concurrently?
Yeah, they're
So a total of 12 months.
12 months.
Okay.
And on the 15 SC 13970, count 1, 12 months probated. Count 4, cruelty, 12 months probated, but this time to work consecutive.
Okay.
Just means that they're running the Kentucky River State. So 24 months.
Any reason why one of them is 24 months and the other is 12? I'm just curious. It doesn't change things, but why wouldn't you have them both be 24 months?
We looked at this as a holistic resolution. We thought it would be information altogether 2 years.
Mhm. Okay. And the two sentences for the two indictments, they do run concurrently with each other. Okay. Got it.
Mr. Jordan, do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has a right to sentence you to the maximum possible sentence in each charge?
Yes, ma'am.
Do you understand that if there are multiple charges against you which you plead guilty to today, the court also has a right to run these sentences consecutively on one after the other?
What that mean? Yes.
So it can be stacked.
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiation that you are expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
And do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Mr. Cotton, Mr. Jordan, do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights?
Yes, ma'am.
The right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of this charge at a trial.
Yes, ma'am.
Is it your decision to waive these rights, which means not to use them and to enter a plea of guilty today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a plea of guilty?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of terroristic threats, CGA 61137 D1, and a simple battery of family violence, OCGA 6522F under indictment number 16SC
guilty,
How do you feel under indictment 15SC 139970 simple assault, family violence, OCGA 6520, and cruelty to children in the third degree, OCGA 6570D2.
guilty,
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
yeah,
Do you understand that you only have a limited right to appeal this guilty conviction?
yes, ma'am,
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition? For misdemeanor charges, you only have 12 months from today to file a habeas corpus petition.
yes, ma'am.
At this time, Your Honor, we'd like to get a factual basis for the plea.
We're fine with stipulating to the factual basis, Your Honor.
Okay, I'm gonna have a few questions about it, but that's fine. So it sounds like Mr. Jordan is stipulating that there's a factual basis for his pleas in both cases. Don't get used to that, though. You'll need to be ready to do your factual bases.
Let me just go on the on special condition, as Commissioner of Probation, the state's asking that Mr. Jordan participate in the family violence intervention program.
Okay, and what about contact? I know that one of the reasons why your office was anxious to connect with Ms. McCullough, McCullough, who is the victim in the 16 SC case, and Ms. Redwine, the victim in the 15 SC case, was to see if they wanted any contact with Mr. Jordan going forward. What did you learn?
As to Ms. Redwine, there'll be no contact with the victim. As to Ms. McCullough, she's not opposed to contact with the victim. She says she's in love with the children and she wishes that it continues to do so.
Got it. Thank you. I think we do. Officer Dixon, do you have any criminal history information for Mr. Jordan?
Your Honor, I do not.
Okay. Ms. Wood, are you aware of anything other than these two cases?
Just these two, Judge, and then the pending cases is all I know of.
Okay. Right. This is the stolen gun in the little satchel he had when he was maybe jaywalking.
Yes, Judge.
Okay. Thank you, Officer Dixon. Ms. Wood.
Thank you, Judge. Mr. Jordan is 29 years old. He did have family support here in court today. He actually lives with his mother and grandmother who were here. He is a lifelong Atlanta resident. He has an 8th grade education. We are encouraging him to continue working on his GED once he is released. He does have gainful employment that he will be returning to. You heard his mother tell the court a little bit about that. It's actually under the National Furniture Installation Service Group. And he also works a second job with fan favorite vending. So he's very eager to get back to both of those jobs. Judge, if I may just give the court a little bit of context on these cases. The 15 SC case is with an ex-girlfriend. The no contact will not be an issue.
That's Ms. Redwine.
Yes.
Okay.
I think this case stems from maybe there was some disagreements. So Ms. Redwine was older, a good bit older than Mr. Jordan. Her girl and children were the same age as him. So if you can imagine.
It's a reality TV.
Yes, Judge.
Okay.
And then for the 16 SC case with Ms. McCullough, they actually were back together after this incident happened. They had another child afterwards. So they are on good terms. As you heard the state mention, he does help with those children. So Judge, we are asking the court just to accept the state's recommendation on these cases.
Which is a total of 24 months of misdemeanor probation.
Yes, Judge.
Okay. Which will leave Mr. Jordan, it sounds like, without a felony conviction.
Correct, Judge.
Okay. Got it. Mr. Jordan, how did you end up getting arrested on these? What was in connection with this supposed jaywalking thing?
Yes, sir.
And then you got a bond on that, but this was holding you in.
Yes, sir.
Okay,
Oh, and if I could elaborate, Judge, I believe, so these are clearly older cases. And I don't know if it was a failure to appear on those, but there was an issue with getting his address updated after the 15 and 16 SC cases. So he has not had any trouble with law enforcement in 6 years or 5 or 6 years.
got it. Until this situation at Angier and Boulevard or wherever it was. Okay. And you worked 2 jobs. Your mom was here saying you better get out because one of your employers loaned some money. What's the second job? What's the fan?
Fan favorite vending. It's like a vending company that we do events like for Georgia Tech concerts, drag racing, and like EDC concerts and stuff.
So what do you do?
Sell food items at the vending.
So like, are you the guy walking around with that, like
With a
that
little
crate strapped to your
yes.
stomach and you're saying like popcorn, that kind of thing?
Something like that. Yeah, or
Okay.
I might be in a booth selling ice, like things like that.
Okay. And which one do you spend more hours at? The furniture one or the vending one?
The furniture one,
Okay. All right. How many kids do you have?
9.
9 kids.
Yes, sir.
Wow. You're 29 years old. Are you trying to do, what is it, sort of 10 a decade or what's the
Sir,
plan?
I'm done with having kids.
You're done. How do you know you're done?
But they're expensive.
They are, well, okay. I didn't
I
ask
have
why
two.
you're done.
So I have 2 jobs now.
But you do have 2 jobs. You're gonna need probably 9 jobs for 9 kids. How is it that you think you'll stop having kids?
Stop.
Well, I mean, but they get made in a certain way. You're gonna
Condom.
abstain from everything? That's a pretty big pitch.
Using condoms.
Okay, that's more detail than I needed, but you're gonna
Oh,
be thoughtful
sorry.
about it. You're gonna be thoughtful about it. Where did you go to school up through 8th grade?
Crossroads, Second Chance.
Okay. How many of your 9 kids are with Ms. McCullough?
2
2. How old is your oldest kid?
with Miss McCullough.
No, your oldest kid overall,
Oh, 14.
14.
Yes, sir.
Okay. And how old is your youngest kid?
8 months.
8 months.
Yes, sir.
Okay. Is that with Ms. McCullough?
No, sir.
No, someone else.
Yes, sir.
Okay. And not Ms. Redwine.
No,
Do you have, I don't know. I'm asking.
No,
Do you
sir.
have kids with Ms. Redwine?
No, sir.
So you and Ms. Redwine can stay apart.
Oh, yes, sir.
Good,
Yes.
because you will. All right. And home for you, when you're not out making 9 kids, is mom and grandma. That's the house where you stay?
Yes, sir.
Okay. What's that address?
564
564
Morgan Street,
Morgan Street.
Northeast Atlanta. I think it's 30308, if I'm not mistaken.
Okay, but 564 Morgan Street, like Joe Morgan, baseball player, Northeast.
Morgan, yes, sir.
All right, in Atlanta. All right.
Northeast Atlanta.
Yep. Ms. Wood, do you waive any issues arising from the fact that we'll be working off of copies of the 2 indictments?
Yes, Judge.
Mr. Jordan, you did sign your plea of guilty form. I don't have indictments to hand to you, but normally you would sign them indicating that you're pleading guilty to the reduced charges. Do you authorize me to sign your indictments indicating your guilty plea?
Yes, sir.
Ms. Wood, may I sign for you?
Yes, Judge.
And Ms. Charles? I will take care of that. Mr. Jordan, I find there is a factual basis for your 2 pleas. This all happened long ago. I'm glad to hear that since then you have more or less stayed out of trouble. You do have these 2 new sets of charges that I think arise from one situation. Those don't go away. Those are out there. You got a bond for them. Make sure you stay in touch with whatever lawyer is helping you with those charges.
Should I get you for my-
I also find that your pleas are knowing and voluntary. Knowing means you've understood all the things we talked about. Is that a fair statement or are you confused about what's going on?
I understand.
You understand? Any questions?
No, sir.
Voluntary means that no one's forcing you to enter this plea, but you have, after talking with Ms. Wood about it and maybe having your mom say you better, you've decided that you want to enter pleas of your own accord. Is that correct?
Yes, sir.
All right, I'll accept your pleas in both cases. In 15 SC 139970, count 1, which has been reduced to simple assault, family violence. I'll sentence you to 12 months, but I'll probate that. And then count 4, because 2 and 3 have been dismissed. I'll sentence you to 12 months. That will run consecutive, also on probation. So total of 24 months probation in the case ending in 970. And then in 16 SC 145475, I'm sentencing you to 12 months to serve on count 1, which has been reduced to misdemeanor terroristic threats, and 12 months on count 2, which is simple battery family violence. But I'll run those concurrently with each other, meaning at the same time, because that's what you all negotiated. And your sentences in both cases will run concurrently. So really what we're talking about is 24 months probation. That first 12 months, you're taking care of 2 cases. And then that last 12 months, it's all related to the situation with Ms. Redwine.
Yes, sir.
A special condition of your probation in both cases is that you enter into and complete a family violence intervention program. That's a class, but it's not just one day. You don't show up and for an hour you say, I won't beat up my girlfriend or something like that. I don't remember how many weeks it is, 8 or 12, don't hold me to it, but you go to class once a week for a while. You're gonna need to complete the whole thing. You don't get to go to 2 and not worry about the rest. You'll need to provide proof that you completed it.
Yes, sir.
In the case ending in 970, the 15 SC case, it will also be a special condition of your probation that you have no contact with Ms. Redwine.
Yes,
You don't call her, you don't write her, you don't do something on her social media page. If you're walking down the street and she's coming towards you, you need to turn around and go a different way.
Yes, sir.
And that's it. I thought about saying you need to get your GED, but you're going to be taking the family violence intervention program and you seem to have navigated life pretty well. The 9 kids is going to, I think, keep you real busy going forward. And so you ought to focus on making some money to take care of them and eventually your mom and your grandma and all the other responsibilities that you've got.
Sure.
Ms. Charles, anything else in Mr. Jordan's cases? Ms. Wood?
No, Your Honor.
All right, Mr. Jordan, anything you want to add or are you good?
No, sir.
All right, you're going to need to stick around. They're not going to take you downstairs right away because you have to meet with misdemeanor probation. Someone's actually going to come here and tell you where you need to show up to do that. We have a probation officer who is on this call,
Yes,
but
sir.
she does felony probation and she would have given you reporting instructions, but you are not catching any felonies in either of these 2 cases,
All right.
which is great for you in terms of getting jobs and all that kind of stuff.
Yes, sir.
All right, thank you everyone for working on this.
Thank you, gentlemen. All right, Mr. Jordan, good luck to you,
Call
okay?
my mom.
Yeah, I'll call her. I'm gonna call her. She's working.
Thank you.
Okay? So I'll follow up.
Thank you, Ms. Dixon, appreciate it. All
You're welcome.
right, take care.
You too.
All right, so we're going to bring out Mr. Payne now for the bond hearing and then we'll be done. So did you know he had 9 kids or that was news to you as well?
I knew that he had 9 children. I wasn't prepared for the court's inquiry.
Mr. Payne, how are you?
Well,
We're going to get on the record now. I'm Judge McBurney, and you've got 2 cases on the plea and arraignment calendar, positions 3 and 4. Ms. Patel, your lawyer, and Ms. Charles, the prosecutor, and I talked a little bit about your cases earlier today. Ms. Patel shared with me that you had at one point been in drug court.
Yes, sir.
How long were you in drug court?
4 or 5 months, I believe.
Who was the judge you were working with?
I don't recall.
Okay. Then drug court didn't work out. These cases, you were in drug court on, but they were sort of diversionary cases, meaning if you successfully completed drug court, then the state had committed to dismissing the charges.
Yes, sir.
But you didn't finish drug court, so these cases are back. And we talked a little bit about whether it makes sense for you to try drug court again, and it may, I don't know. Drug court needs to decide whether they take you back. I don't know why you were terminated, and sometimes you don't get to go back. Other times they'd love to have you back. The termination had to do with you being really in the thick of your addiction, and it would make sense to try again. Today, though, we're going to stay focused just on the question of bond. Ms. Patel shared with me that you want to have a bond hearing. So I'm going to pull up one of your files here on my screen. You can see what's happening. And we'll talk about bond. What are your thoughts before we do that about drug court? Do you want to try again, or it was a bad experience, or how are you feeling about that?
Necessarily a bad experience. The thing was, I was having the difficulty with working and going through the program because 3 days after I was released, I was working 12 hours a day and then having to go right back to the program, like from work, pretty much.
You have to speak right.
Is this better?
Yeah, it's better.
Well, the problem before was my work schedule was interfering with the court, with the program, because 3 days after I was released, I started working and doing 12 hours a night.
What kind of work?
Warehouse. I was
Okay.
at the Clorox factory.
Okay. That was a long time ago, and then you sort of disappeared on us. What have you been basically working the whole time, or that
I've
stopped?
been working off and on since, yes.
Okay. All right. You can pop your mask back on. That's okay. We needed to hear you. Thank you. All right. Ms. Patel, why don't you tell me your thoughts about bond for Mr. Payne, please?
Thank you, Your Honor. Mr. Payne, given that those two cases were track one referrals, he does not have any felony convictions. I understand that the state does have concerns with him being able to appear, given that he's currently here based on a bench warrant that was issued. I believe that the issue that may have arisen over there was just the lapse in getting him on a calendar after he was terminated. And the difference in attorneys, they've changed the way things are being handled with terminated cases now, but it went from the drug court attorney to my caseload in Judge Downs's courtroom. And so I still haven't tracked down the original files just yet. I did speak to his cousin. He would be staying with his cousin, Gary Norman. He lives at 3225 Dressel Lane, apartment 6, East Point, Georgia, 30344. I talked to his cousin a little bit about whether this would be a good address for him while he waits to hear back on drug court, given his issues with relapsing. His cousin says that Mr. Payne has stayed with him before, that he runs a pretty tight ship. He's never indulged or allowed for any of that behavior in his home and has not had an issue with that. It's just that when Mr. Payne leaves his cousin's house and decides to stay elsewhere, that he finds himself in this situation. His cousin also indicated to me that he's got a job lined up for Mr. Payne to work as a janitor. I explained to both Mr. Payne and the cousin that the issue before was him juggling a job and drug court, and that at this point he would have to prioritize drug court. If he does get back in, it would have to be something that he'd be willing to leave if he has to leave. Mr. Payne has offered to the court that if he's released on bond, he would be willing to agree to an ankle monitor or whatever services Your Honor felt most comfortable placing on him as a condition. I spoke to Ms. Charles about maintaining perhaps that status date a month or two from now, so that should Mr. Payne not come to court, a bench warrant could be issued, but just so that we could maintain communication with him upon release. And so Mr. Payne is at the point where he wants to do drug court. He's just not, he does not want to remain in custody while we wait to see whether or not they'll take him back.
Okay, and how was it that Mr. Payne ended up back in custody?
He picked up a misdemeanor. So he is currently under sentence. They sentenced, it was a 12 serve 90 days, which with the 2-for-1 is 45 days. So he does have some bit left on that. He knows he won't be immediately released.
What was the misdemeanor offense?
I have it as a theft by taking
Yes.
from, I believe it was a hotel room that he was staying at.
Yes.
Mr. Payne, what is the Judy Lane address? You used to live on,
It was a prior address that I was renting a house there,
okay,
and I've just had a change of address since then.
and then how long ago were you arrested for this hotel situation?
In October.
October? And at that time you were living in the hotel, or it was just a place where you were staying briefly?
I was living there at the time,
Okay,
and I believe the sentence end date is the 16th of December.
if you get the 2-for-1.
Yes, sir.
Okay.
Well, they said that I could.
Okay. So today's the 7th. All right. And when you get out, if you get out because you have a bond and your misdemeanor sentence expires, the custodial part, why is it you think you can live at Dressel Lane?
Well, I don't.
Has the
understand.
person said you can live there, or you're hoping you'd live there?
No, we've both, yes, he said it would be prudent that I actually live there. So to help me to not have any slip ups.
Okay. And when you say slip ups, meaning a relapse,
Yes, sir.
what is the substance or what are the substances you struggle with the most?
Alcohol, marijuana, and sometimes cocaine.
Okay.
But like at the moment, he has he's been taking care of my kid, and I
Taking care of your,
I have a 2-year-old. Well, she'll be 2 in February.
you have a daughter.
Yes, sir.
Okay.
And I just want to kind of.
Miss, the person who lives at Dressel Lane is taking care of your daughter?
Yes, sir.
Where's your daughter's mother?
We lost her to COVID.
To COVID?
Yes, sir.
Sorry. What's your daughter's name?
Nola.
Nola?
Yes.
All right, Ms. Charles, your thoughts about Bond and Mr. Payne.
The state is not.
Can you turn the microphone on? I think that'll help. There you go.
And at this time, the state does not oppose, Your Honor, setting a reasonable bond for the defendant. The state sort of reviewed, considered all of the circumstances surrounding Mr. Payne's situation. However, in spite of the state's willingness to consider a bond, the state does have a significant concern as it relates to prong 1 of the Ayala factors that Mr. Payne said it poses a significant risk of failure to appear when required. Mr. Payne sort of disappeared from the court's reach on or around April 23rd, 2019, and but for the recent misdemeanor, the cases would have been on judicial hold. And so we would want to ensure that should the court grant a reasonable bond, it would come with the requirement that he be placed on ankle monitor, and that way we can keep track of Mr. Payne, as well as keeping him on status for the next 30 or so to 60 days, so that we can always be in constant contact with him and maintain oversight of his whereabouts. Your Honor, if you'd like, that's a brief summary of the facts that bring us here. Go back to the first one, on 16 SC 143057, Mr. Payne was charged with burglary in the second degree, 8 counts, I'm sorry, 6 counts of theft by taking, a total of 7 counts in the indictment. On and around April 12, 2016, Mr. Payne was a resident of the Sheraton Hotel, which is located on 165 Cortlandt Street, Atlanta, here in Fulton County. After Mr. Payne checked out of the hotel around 3 o'clock that day, multiple staff members observed him roaming the hallways and roaming in the areas that were restricted from regular paying guests. Officer Mitchell was dispatched after multiple housekeeping ladies reported that their belongings had gone missing from the restricted staff area. And once hotel security entered the bedroom, as Mr. Payne had previously been living in, they noticed that there was an object placed in the door jamb, which prevented it from closing. And once hotel security accessed the bedroom, they located multiple tablets and cell phones that were later identified as belonging to ECRM, which is a marketing company, which was in the conference room of the Sheraton Hotel. And Mr. Payne was charged accordingly. Subsequent to that, Mr. Payne also picked up another indictment, 17 SC 152188, where he was detained at the local CVS for a shoplifting charge. The CVS pharmacy was located at 520 Boulevard in Atlanta. In a search incident to arrest on Mr. Payne's person was a vial, which was later confirmed by the GBS, containing a white substance, methamphetamine, and also a second vial with a clear liquid, which was later confirmed to be a non-controlled substance. So based on Mr. Payne's charges, the state is aware that he struggles with substance abuse and he does need some treatment, which is why we are willing to consider not oppose a reasonable bond in this case and consider Mr. Payne for a second try at drug court. And so, Your Honor, we also consider the fact that since Mr. Payne sort of was determined from drug court, he has picked up no new charges and his GCIC was updated and there's nothing new, no further felonies. And so we just ask Your Honor to consider the fact that Mr. Payne poses a flight risk of failure to appear, but for that, we take no other issues with Mr. Payne.
Okay. Ms. Patel or Ms. Charles, I don't know who'd be more familiar with this. I think there is right now, thanks to COVID/relief funding, there's a way to get ankle monitors where the defendant doesn't have to pay for them. Is that your understanding? Is that only for non-complex or pre-indictment, or what do you know about that?
Your Honor, I believe, excuse me, that there is no prohibition from a Superior Court judge allowing someone to be released on a county-funded ankle monitor. It just has to specify that in the order itself, that it would be paid for by the jail.
Well, I don't know that I say the jail. I know that we have these county-funded ankle monitors because one of our first ORCA calendars just this week with a senior judge, and we're moving things, was related to people who had been on county-funded ankle monitors. They cut them off. They've since been caught. What do we do? But that's what raised in my mind, wait a minute, how are these guys getting county-funded? And these are pre-indictment. So given to them pre-indictment, why couldn't we use that same pool of resources? And the only part of the answer I got was, well, with all this relief funding, there is partly to relieve the pressure at the jail. And I think a couple of your senior managers met with a couple senior ADAs over the summer, and they just identified folks like, hey, let's give them an ankle monitor and get them out of jail. I'm just wondering if that resource exists? And your understanding is that we could say release on county-funded ankle monitor.
Correct. I think that the resources are still available. I just haven't had to do one in a while. I don't remember the exact wording that's
Okay.
used on the orders, but
I'll figure it out.
it's still there.
So here's what I'm going to do. We're not doing anything today. I'm intrigued by the ankle monitor option. I'm dissuaded in part by Mr. Payne's history of disappearing. I can't quite tell why he was terminated from drug court, but he has had a number of bench warrants in these two cases, not showing up. Judge Ellerby was your drug court judge, by the way. Not showing up to Judge Ellerby, not showing up to Judge Downs. And I see that as symptomatic of your relapsing. So
It also may have been changes of address.
true, but I think that one reason why you're bouncing from a hotel to someone's house to a hotel is that because of your addiction, it's hard for you to maintain a stable situation. That's me speculating. I don't know. You don't have to justify it, but your way of life over the past few years has made it hard for you to reliably show up for court. So to Ms. Charles's point, that's the main factor that I'm supposed to consider about bond. I don't get the sense you're going to go out there and be running and gunning. You just might not be taking good care of yourself.
That has changed for me since I've had one since Nola.
Since Nola arrived.
I haven't been. I've tried to be a better man.
Good. That's often a great motivator. Folks who are in drug court who have a child involved in their life sometimes are a little more motivated to make difficult changes. I am going to reach out to drug court to see if we can expedite an intake evaluation of Mr. Payne. Ms. Patel, you are going to do two things, please. One, you're going to get confirmation from whoever occupies this Dressel Lane that Mr. Payne can stay there. Email is fine, doesn't have to be anything formal, but I'd like confirmation that that's a place where Mr. Payne can stay. And then number two, you are going to figure out how one says, please give me a county-funded ankle monitor. Or how the judge says, please give to Mr. Payne a county-funded ankle monitor. We'll bring all those strands together. I'm mindful that for 9 more days, Mr. Payne couldn't go anywhere anyway. I could give him, I don't think burglary in the second degree qualifies for a UJR, but I could set a real low bond, and it sounds like Mr. Payne might be able to make it. I'll tell you what I'm much more interested in is having Mr. Payne be released to support. And it sounds like there's support at Dressel Lane, but it would be great if we could have a little bit more wraparound. Here's drug court. And I'm confident, even though you are eager to work, that we could help you strike a better work recovery balance. That happens with clients in drug court all the time. Working is good. We don't discourage people from working. But as Ms. Patel was saying, it just needs to be something that supports your recovery as opposed to gets in the way of it.
But the job that my cousin has in line for me, it goes around my court schedule.
Fantastic. A lot of employers are willing to do that. And now, because of the pandemic, a lot of drug court is virtual anyway. And so it's the kind of thing where you can take a timeout from work, go to a quiet space, you're on your phone, and you're connecting with drug court as opposed to going all the way down to Hope Hall. So food for thought as to whether that might work. And then we can reconvene. It may be, Mr. Payne, that rather than bringing you to the courthouse, we're having you appear via Zoom. A lot of inmates are doing that. I wouldn't want you to miss a chance for us to talk more about your case because you're at the jail and we can't get you here. So don't be surprised if the next time we're talking, you are appearing virtually. I'll be here. Ms. Patel may be here. She may be on the screen, but you'll be able to see her. But finally, Ms. Patel, I'd like you and Mr. Payne to talk about whether he is comfortable letting you handle some of this without him being virtually or physically present at all, because as we approach the 16th, it may be it's more emails and phone calls as we're trying to sort this out. If drug court can move quickly in assessing Mr. Payne and considering that, we may not have the ability to connect him virtually or in person. So you guys talk about that, and we'll take it from there. Any questions about that, Ms. Patel?
No, Your Honor, I just wanted to add that at least with regards to step one, I did speak to the cousin and over the phone today and prior to this court date. So I have at least confirmed that address, but I will work on steps 2 and 3.
Okay, great. Ms. Charles, any questions about Mr. Payne's situation?
No, Your Honor.
All right, Mr. Payne, did you follow what I was saying, or do you have any questions?
Was there a bond about or was?
There's a pause on the bond hearing.
And we may convene it formally if time permits, but you and Ms. Patel are going to talk for a minute to see if you're comfortable letting her represent you, even though you're not in the room, about working this out. I'm not opposed to certain things about a bond, but it would be great if drug court can move quickly enough to get you released right on into the program. But that's assuming, I guess, Ms. Charles, I did not mean to make decisions for you. That would be assuming that Mr. Payne is going back into drug court with a diversionary recommendation as opposed to part of his sentence. And is that something at this time you're comfortable with?
We've talked of both options. We haven't reached a resolution.
Okay. Well, keep talking about that. And we'll see if Mr. Payne, in fact, has no felonies on his criminal history, then option 1 would be a consolidated first offender plea. Option 2 would be, let's try one more time with a diversionary entry into drug court, but 100% your guys' decision to make. I stand ready to do what we can to make it happen. And I'll reach out to drug court when I get out of here to see what we can do. All right. Thank you, everyone.
Thank you, Judge.
So I need to do Mr. Jordan's final dispose.
Yes.
Because they won't show up until then.
Judge.
Yes, ma'am.
If I might add, I looked up, I have a former client who had a bond through Judge Revocation. I don't know if you remember Mark Cruz Walker, but she wrote in her order for the bond that he should be fitted with an ankle monitor prior to release through the jail, and then the ankle monitor shall be paid for by the county.
Okay.
So I guess you just have to specify.
It's the 2-step piece that, hey, jail, you put it on him. I just, when someone said, hey, paid for by the jail, I learned the hard way. You don't try to hang expenses on the wrong accounting unit, because then they're like, wait a minute, that's not in our budget. It's a different budget. But that may be the magic language. You're saying that was Judge Emily Richardson who did that? Okay. Good.
Okay.
Yeah, then we have the language. And that, did it happen, or is that person still in jail?
So he actually got out. He has a new charge now.
Okay, but he got out with the ankle
He
monitor.
did get out.
Okay. Didn't do him a lot of good, but he got out. Great job, Ms. Charles.
Thank you. Yeah, thank you. Good work.
So have you already gone away, or you are going away? So you're going far away sometimes.
I'm going away from the 17th through the 29th.
Going back to the homeland?
No, we're going to cruise.
A cruise.
Yes.
That sounds not COVID safe. Good luck with that.
But if we actually have the options, we could go with this is desperate to get away for a bit.
Yeah.
And since you have to be fully vaccinated and all that, so I figured, it's limited capacity.
Mhm. Where is the boat going?
It's going to St. Thomas, San Juan, Dominican Republic, and the Cove, and Rancho.
Wow, that's a long cruise.
Right there.
That was your cruise?
That was your cruise.
Do you vouch for it? It was a good one?
I didn't go. We didn't
Oh,
go.
because of all this stuff. Okay.
Let me know how it is. Let me know how it works out. Enjoy it.
Is this your first cruise, or you've done that?
It was my third cruise.
Third cruise?
My last cruise was 2 years.
Okay. So you're a cruiser.
So some colorful drinks.
Nine kids. That's so many. He's a little guy too. Yeah, yeah. You can't. I mean, it's
I'm gonna try tomorrow.
not a good.
See everybody. So yeah, that's fine.
All over the place.
Yes, definitely, because I do. There's one case that is a little, well, it's not complicated. It's probation or revocation.
The only question I have is,
CPP's just okay. This is that by shop thing, and I.
Reset a few weeks out. Ms. Charles wants to reach out to Mr. Ross, who is the business owner. So whatever works for you scheduling wise, but if it needs to be noticed, then it needs to be however far. This is not a burning one. This is just something that will benefit Ms. McKay. So if it's January, it's January.
Yeah, and I looked up the new vision, it didn't look like too crazy. We basically put a bunch of.
All right, you've got the two final dispositions. I will finish the indictment.
That's why we were, right. But I will, I'm gonna swap. Yes.
Take care.
So yeah.
Whoops.
Because it's been a while since.
Right. Yeah, totally. Exactly. Yeah. Totally. Oh, she's remembering. Right, right.
Thank you for catching the door.
Yes. Oh, yeah. Hi, Judge.
See you guys. So how'd we do back there? Did everyone behave? Apparently there were a lot of people who, oh, let me in this. Hold on, let me in the.